This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
And we are now joined by Todd Lutsky from the law firm of Cushing & Dolan, here to answer your questions about your estate plan. Studio lines are open at 888-205-2263. That is the number to call to ask Todd your question about your estate plan live on air. 888-205-2263. Get calling now. We usually only have time for a few calls to get through. So, again, that number is 888-205-2263. One more time, it's 888-205-2263. Mr. Lutsky, how are you today?
I am never better. How are you?
Tough night last night.
What'd you do?
I had a dream that I was a muffler.
Yeah?
Woke up exhausted.
Yeah, no, that does happen.
Yeah.
Yeah, it's horrible.
Brutal.
Yeah.
Brutal. Not good. Let's talk a little bit about trusts, which I know is kind of a horrible introduction for an estate planning attorney because that's kind of a broad topic.
Yeah.
I want to narrow that down.
Good.
Irrevocable trusts, the Medicaid protection kind.
Mm-hmm. Mm-hmm.
How do they actually work? What do they do?
Of course.
It's kind of like magnets. How do they work?
Yeah, of course. That, and I'm going to have to narrow that down further because, of course, I could spend probably an hour and a half, 2-hour seminar explaining how they work. But we're gonna pick it apart.
You got 2 minutes.
I know. We're gonna pick it apart. So I think what people need to understand is, as you said, Chuck, appropriately, Medicaid irrevocable trust. That in and of itself tells you that there's other kinds of irrevocable trusts that might strike more of a fear into people because they think rigid, inflexible, I can't change it, I can't do anything. And those trusts do exist. This isn't one of them. This Medicaid irrevocable trust, if I can emphasize anything about how it works, is how much control you as the creator, the donor of the trust, will keep. And that's what I want to stress. So let's start off with that. Many, many people say, well, what can I do? What can I not do with these irrevocable trusts? What goes in them? What doesn't go in them? Well, let's start with a house. Most people put a house in. That's a big asset. That's one they want to protect from the nursing home. And if that's the only item you put in there, it's so easy because you set it and forget it. There's nothing to do. There's no income being generated. I'm not renting it. I'm not filing an income tax return. Great. What can I do with it? Well, you can live there, much like you do now. You get to pay all your real estate tax bills and your utility bills. Hooray. Much like you do now.
Mm-hmm.
If you ever did want to rent it, you could rent it. I'm not saying you will, but at least that option remains on the table, like now. And you could collect the rent, like now. But more importantly than all of that, everybody says, well, that's great. Nothing's changed, Todd. Except if we want to move. That happens. Get older, you want to move south, you want to maybe go up to New Hampshire, sell, move.
Happens really frequently.
Yeah. These are things that people want to do. I'm not going to put in a trust if I can't do that. You can still do that. So it's wonderful that you can direct the trustee to sell the property. The money goes in. The money goes out and a new piece of property comes in. I mean, this is literally like you selling it personally, except it's sold through the trust. And I think what's most important is even if you end up moving to, let's say, Florida, the trust can stay with you. Doesn't have to change. And most importantly, you haven't reset the 5-year waiting period when you do that. So it's not like, oh my gosh, I have to start over. I've had it in there for 8 years already. No, you don't. So just a little flavor, folks. Again, so many things you can do with the trust. That's just one that I wanted to get out there because people have houses, and it's one of the most important things to put in the trust.
Talking with Todd Lutsky from the law firm of Cushing & Dolan. If you have a question that you'd like to ask Todd about your specific estate plan, we've got the studio line open at 888-205-2263. 2263. That number again is 888-205-2263. We are going to take a quick break here, but when we come back, it's going to be right to your questions with Todd. Still have a little bit more room on the phone, so if you do have a question, this is your opportunity. 888-205-2263. One last time, that phone number is 888-205-2263. Your calls right after this.
Ask Todd with Todd Lutsky every Wednesday at 10:30. Only here on the Financial Exchange Radio Network.
Alrighty, let's get right to your calls with Todd Lutsky here. Let's go first to Bruce in New Hampshire. Bruce, what's your question for Todd?
Well, here's my question. My family, the three of us in the family, three siblings.
Mm-hmm.
We own a house down on Cape Cod.
Mm-hmm.
Each of the siblings has children.
Okay.
We need to figure out some sort of a trust or something to pass this down to the next generation.
Mm-hmm.
And the plan is that everybody wants to keep this in the family. It's been in the family. It's a summer house only.
Yep.
So the way it is right now with no setup, if one of the three was to die,
Mm-hmm.
God forbid, it would automatically go to the other two partners, not to their descendants, correct?
Well, let me ask you, this is a question for you. Have you looked at, that was what I was going to ask you, have you looked at the deed? Does the deed have, A, B, and C, the three names, joint tenants with right of survivorship? Or does it say A, B, and C own it as tenants in common? You really need to know that answer to that question before I can answer your question. So do you know that answer, or are you not sure?
If I'm not mistaken, which I could be, I think it's tenants in common.
Great. So if it says tenants in common, then the property will pass according to A, B, and C's own individual estate plan. It will not go to the survivor. But it's very important when siblings own things like this, 1/3 each, to understand how it's owned. Okay, so first and foremost, if it's tenants in common, you're better than joint tenancy. I don't know that I love that arrangement still, but it's better than joint tenancy because you're right. If it was joint tenancy, then it would go to the survivors when one dies and disinherit the person who died's family, spouse, children, etc. So you don't want that. Secondly, I wouldn't own it the way you're owning it. Now, it doesn't sound like you're renting it. It sounds like you don't have any liability concerns, but each of you really need to do your own estate plan, right? You want to, one, make sure it avoids probate when one dies. Two, you want to make sure it goes to your side of the family. Three, if it's something you want to keep in the family, not knowing what the rest of your estate looks like, you might need an irrevocable trust for your third, and then everyone does their own planning. But if you don't, and any one of you gets sick and need nursing home care, you could lose the house, right? So if someone, A, B, or C, goes into the nursing home, well, the other two might be forced to buy out the house in order to prevent it from being taken by the nursing home. So perhaps irrevocable trust planning would be right for all of you. Don't know. Maybe you're self-insured. Maybe you have enough other assets to handle the nursing home. Then I would shift my attention to maybe more of a revocable type trust and worry about how to keep it in the bloodline. So get it to those grandchildren. Show how it gets there. Protect it from future divorces. And even maybe, if you want, have it set up to get to one more generation before you run into something called the rule against perpetuities. So you can probably keep this in trust for almost a third generation, but get the trusts done, get your planning done. So that's a great question. And folks, just like that, this is and for their situation, I mentioned irrevocable trust. Maybe they want to keep it in the family. Maybe they want to make sure it doesn't get taken by a nursing home so that it stays in the family. Then maybe their plan is to use an irrevocable Medicaid trust, which is the exact trust that's described in our guide this month. This is called Unlocking the Power of Medicaid Irrevocable Trusts. If you've never had one, but you've been afraid of the word irrevocable, and many people are, this guide is for you. It'll help you understand what you can and cannot do. It's done in a question and answer format. It tells you all the things that can be done while you're living and all the things that can't be done. You'll find the can't be done category very small, and I think you'll be pleasantly surprised with how much control you have over the assets that go in here. It explains how they operate. Get the guide, 866-848-5699 or legalexchangeshow.com. Again, 866-848-5699 or legalexchangeshow.com.
Todd, we've got another caller for you. Let's go to Jerry in Randolph. Jerry, what's your question for Todd Lutsky?
I want to know if I could make a will without an attorney in Massachusetts.
Well, can you? I think you can. I think there are programs out there. I hesitate. I say kind of say God forbid, but you absolutely can go online somewhere. I think there's softwares, there's programs that are available that allow you to make it. Hopefully you hit the right button. Hopefully you pick the right options, and hopefully you follow the rules that make a will a will. In that regard, it would be, it's got to be signed. It's got to have a testamentary language in there regarding an affidavit. So it's got to have witnesses. It's got to have a notary. It's got to have the language that says, I hereby revoke all prior wills, among other things. So there's requirements. Can you do it on your own? Perhaps. Give it a shot. And lastly, I think you probably need more than a will, because a will in general is a won't in my eyes. It won't it won't avoid probate. It won't protect assets from a nursing home. It won't reduce estate taxes. I don't know if any of those things are things that you want to do. If you do want to do those things, then you're going to need way more than a will. So hope that answers your question.
Todd, I've got one more queued up for you. We've got Annie in Topsfield. Annie, what's your question for Todd?
If you have an IRA and your husband is one of the beneficiaries,
yes,
I heard that that's okay.
Yes,
he will have no problem. But if you add your daughter to it, she might have a problem.
Well, when you say a problem, let me explain what that. First of all, it's 100% if you die goes to your husband, correct?
Yeah, but what if he dies?
Well, you always add a contingent. So first you have a primary to the husband, second a contingent to the kids, or whatever kid or child you want it to go to. So it's a primary and a secondary. I thought you were saying, what if I want to leave half to my husband and half to my child? I don't know that it matters. You can do that as well. But generally it's a primary beneficiary, which you are absolutely right. From an income tax perspective, it should be the spouse. They get the best income tax treatment from an IRA. And then the contingent, so you're right, what if you and your spouse are traveling and you die at the same time and now you need a contingent? The contingent beneficiary should be a child or whoever you want it to be. But list that contingent person so you don't have it blank. If it's blank, it's going to go to the estate. If it goes to the estate as a default, it could come out over 5 years depending on your age when you die. So not always the best to do just on its own. Now, when you say is one better than another, there is a sense that when it goes to a kid, they will have to take it out over 10 years. That's the new distribution age, the new distribution rules for a child, and that could cause a higher income tax for that child to be paid. So hopefully that helps.
Mr. Lutsky, thank you so much for joining us today.
Always a pleasure.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing and Armstrong do not endorse each other and are not affiliated. Elder life planning can be overwhelming, so make sure you're prepared, or you could make costly mistakes that affect your overall plan. Irrevocable trusts are the most common type of trust that folks use for financial protection, and while they can be complicated to create, they help keep your assets safe because they contain specific protections that many of us need, like the possibility of eliminating your estate taxes. Cushing & Dolan are experts in elder law and taxation, and they can devise a plan that covers you in every area where issues can arise. Their new guide is called Unlocking the Power of Irrevocable Medicaid Trusts. Learn more about how these trusts can benefit your family by calling 866-848-5699 right now. That's 866-848-5699. Or you can request the guide right now by visiting LegalExchangeShow.com. The proceeding was paid for and the views expressed are solely those of Cushing & Dolan. Cushing & Dolan and or Armstrong Advisory may contact you offering legal or investment services. Cushing & Dolan and Armstrong Advisory do not endorse each other and are not affiliated.